Hey everybody, it's Roger Thorpe here, president of Thorpe Benefits. I'm excited today to get into some legal area of employee benefits. My guest is Chris Ashkar. Chris and I have got to know each other and got really into the weeds of some really interesting benefit and legal concepts. We're going to try to tackle a few minutes of time today and just give you something you can handle. And we're going to focus mainly on the issues that relate to absence and disability. So before I start hitting you with questions, Chris, do you want to just introduce yourself to the audience or whoever's
Sure.
watching?
Sure. Thank you so much, Roger. So my name is Christopher Ashkar. I'm the principal lawyer at Ashkar Law. We're a number of lawyers who practice in the areas of labor, employment, human rights, and anything litigation and preventative when it comes to the workplace. So thank you for having me.
You're welcome. And I just realized I didn't pronounce your name properly.
No
So thank
problem.
you for
Yeah.
correcting me. All right, cool. Well, let's get right into it. So the first question, and these things kind of blend together, is maybe you could give people who are thinking of all the things that can happen with an absence situation, all the legal implications that can occur if an absence leads to either a claim, an actual LTD claim, or it doesn't go that direction and it has to eventually be terminated in some way. So we'll get a little more detail, but why don't you just address that first in general?
Sure. So the safest approach is never to write off an employee that has absence issues or anything related to disability issues as a terminated employee or about to be terminated. The reason for that is not only does it open a kind of worms when it comes to wrongful dismissal claim, but it also will bring the sense that this may be related to the disability itself, which is a human rights code issue and a human rights violation. So not only will the employee claim those types of damages when it comes to wrongful dismissals, but also will try to get extra damages under the human rights code, which is a whole big problem that employers should try to avoid.
Okay, so I guess it's generally the word is be cautious.
Be cautious and never treat all the employees and all the issues in the same way.
Right,
Try to prevent issues before they come up, and that's being more understanding and compassionate rather than
right.
having a one policy fits all.
Okay. And I've heard the same with our involvement in absence management. It is about having a consistent way to treat people and being in connection with them throughout the whole process, as opposed to stepping aside and letting, say, a provider do all that. It needs to be a human relationship throughout that. So thanks for that. So, okay, let's say you're being careful, you are communicating well, you have policy and consistency there. Let's say it does end up as a disability claim. One of the questions we get a lot is how long should I maintain the employee's benefits while they are on LTD? And I think there's been different opinions on this. What's your take on that?
It is a tricky question and tricky situation to navigate. So I'll try my best to give, as good of an answer as I can in this short period. Uh, Generally, employers don't have an obligation to continue health and dental benefits when an employee is on long-term disability because they're not considered to be actively employed. That said, if that employer does continue making these premium payments and to cover the employee during a certain period, then the understanding will be that they will have to continue making those payments. So it's generally better to stop them almost immediately. The answer will also depend on who's making those premium payments. If they're shared premium payments or they're covered entirely by the employer, so it's always better to check with someone like you, Roger, or someone like us before taking these actions because they really can cause some trouble later on.
So that answer is a bit contrary to what people have been dealing or doing over the years. A lot of them would have a written policy that says we're going to continue health and dental for a year or two. And then, so if the policy says that, the person will get a notice, well, you're up to that limit, right? Now, I think what you're saying is truly um, continuing the benefits is almost like setting a precedence that the benefits will keep going as opposed to saying you're no longer active. It's not even appropriate for us to continue that aspect of the benefit plan, right?
Well, the default is, sorry, Roger, the default is to go to that policy to see what you have done and put into writing.
Right.
If you didn't do that, then you can have a policy that says we will stop making payments towards those benefits as soon as you're no longer actively employed.
Okay. Okay. So it's either have a policy or be very straightforward with discontinuing the benefits right away. Okay. I guess it's that middle ground where people don't have anything and they do different things for different employees where they get into trouble. Okay. Okay. So the follow-up to that then is you talked about premium obligations, contributions of cost between the employer and the employee. So that could be an issue even pre-disability or post. Still talk about sort of how that works, that obligation.
Sure. So the tendency of employers a lot of the time now in our age of really trying to scramble for employees is to make all payments and cover all the premiums. And that can be problematic later on because if this employee goes on a disability, then the benefits would actually have to continue in terms of the premiums that would have to be paid. However, if the employer shares these payments with the employer will have to provide the opportunity for the employee to make those payments themselves or the difference or the same contribution that employee would normally have to make, and for that to continue. That has to be done first for the employer to be continuing to make their own contributions. And then if in those cases, the employee fails to continue making those payments, then the employer, it's fair game for them to just stop making the premium payments, but they should give warnings first to that employee before they just cut off the disabilities.
Okay, that adds another nuance to this in terms of who's paying for the premium altogether or in partial. But I think having a procedure in mind that if someone is contributing, they need to continue to do that. And I think you're right. I think some employers would just say, no, it's okay. I'll cover your premiums for you. But again, not necessarily the right thing to do because it could sort of come back to get you later. So again, another reason altogether to just revisit what you do and to be consistent with it and follow through. And number one, get you on the phone to ask about the situation in the first place, right? That's great. I think that what we wanted to do for our audience today was just give them some caution and give them some direction on this delicate area of absence and disability. Any final thoughts before we let you go, or did we cover it?
It's better to be safe than sorry and check before you execute on anything. And, maybe and hopefully we'll do more of those that will get to answer more of these questions. But I think this is it for now.
That's great. Thank you for this. You're right. There's more legal related questions that connect with benefits that we can address down the road. So Chris, thank you so much for your time today. I really appreciate what is a really kind of a tricky and delicate area of employee benefits. So
my pleasure. Thank you for having me.
Thanks, Chris. Bye.
Bye-bye.